of SAE Education Limited versus Commissioners for Her Majesty's Revenue and Customs.
Lord Kitchen will explain the reasons for this judgment.
Supplies of education to students in the United Kingdom are exempt from VAT if they are made by a college or a university within the meaning of Note 1B to Item 1, Group 6 of the Value Added Tax 1994. This appeal concerns the criteria to be applied in deciding whether an institution is such a college. The Appellant, SEL, provides education to students in this country. It maintains that these supplies of education are exempt from VAT because it is a college of Middlesex University. The respondents, the commissioners, disagree and assessed SEL for VAT in respect of its accounting periods from May 2009 to February 2012. SEL's appeal against these assessments was allowed by the First-Tier Tribunal. The commissioners appealed against that decision to the Upper Tribunal, which allowed the appeal. SEL then appealed to the Court of Appeal, but its appeal was dismissed. SEL now appeals to the Supreme Court. SEL is part of a group of companies which trades around the world under the name SAE Institute, or SAEI. This group is a very well-known provider of education in audio and digital media technologies. SAEI has carried on business in the United Kingdom since 1985. That business was first conducted through a company called SAE Education Trust, SETL, but since May 2009, it has been conducted through SEL. Middlesex University is a United Kingdom university. It has never had any financial interest in any SAE group company, and no Middlesex University employee has ever been a director of such a company. Similarly, no SAE group company has ever had a representative on Middlesex University's governing body, or has played any part in its governance. Nevertheless, for many years, the relationship between SAEI and Middlesex University has been extremely close, and SAEI's educational activities in the United Kingdom have been closely integrated with those of the university. Admission requirements were set by SAEI, but had to conform to the university's general requirements. Students who met those requirements were selected by SAEI using procedures agreed by the university. Selected students were enrolled by SAEI for one of the university's qualifications. Enrolled students were considered members of the university and taught by SAEI, subject to the university's quality safeguards, and in due course, the students were assessed by SAEI, subject to the university's regulation, and, if successful, were awarded a degree by the university. The collection of VAT in the European Union has been harmonised by a series of directives, culminating in Directive 2006-112-EC of 28 November 2006, the Principal VAT Directive. Article 132(1)(1) of that directive says that Member States shall exempt certain matters in the public interest, including the provision of university education by bodies governed by public law, having such as their aim, or by other organisations recognised by the Member State concerned as having similar objects. Article 133 contains examples of conditions Member States may impose, and says that Member States may grant to bodies such an exemption if, among other things, they do not systematically aim to make a profit, or the exemption would not be likely to cause distortion of competition to the disadvantage of commercial enterprises subject to VAT. In implementing the Principal VAT Directive and its immediate predecessor, the Sixth Council Directive, the United Kingdom therefore had a discretion in deciding which bodies, other than those governed by public law, it would recognise as providing university education. But that discretion was limited, and while it was open to the United Kingdom to exempt educational services provided by private bodies for commercial purposes, it could not do so without consideration of the objects those bodies pursued. It was also required to respect the general principle of fiscal neutrality. The Principal VAT Directive has been implemented in the United Kingdom in the form of the 1994 Act. This says, in Item 1 of Group 6 of Schedule 9, that exempt supplies include the provision by an eligible body of education. An eligible body is defined in Note 1b as including a United Kingdom university and any college, institution, school or hall of such a university. The outcome of this appeal therefore depends upon the meaning of the phrase college of a university in Note 1b. The term university is not defined in the VAT Act, but the conditions under which a body in the United Kingdom is entitled to call itself a university are regulated by statute. Over 100 bodies are presently entitled to call themselves a university, and they vary a great deal. A small but significant number of them are private and run for profit. Many universities comprise or have close relationships with colleges. The court finds that it is against this background that the phrase college of a university in Note 1b must be construed. The following points are relevant. First, any college, as an eligible body, must provide education. Secondly, since the phrase United Kingdom University in Note 1b extends to private universities run for profit, the same must apply to the phrase college of a university. There can be no justification for treating them differently. Thirdly, there is nothing in Note 1b which would justify limiting the phrase college of a university to colleges which are a constituent part of a university in a structural or constitutional sense. If there were, it would effectively exclude commercial providers such as SEL, for it is a test they would rarely, if ever, be able to satisfy. That would be contrary to the principle of fiscal neutrality. Fourthly, the United Kingdom must be taken to have recognised that a college of a university within the meaning of Note 1b has similar objects to those of a university which is governed by public law. This focuses attention on the objects of the body and the nature of the services it supplies, and how integrated they are with those of the university. If a college is a part of a university in a constitutional or structural sense, then it is overwhelmingly likely that any educational services it provides will reflect that relationship, and so the college may properly be regarded as a college of a university within the meaning of Note 1b. But it does not follow that the converse is true. It is entirely possible that an independent and private body, which conducts its business of providing education for profit, is so integrated with the university that its educational activities and objects are indistinguishable from those of a college which is constitutionally or structurally part of the university, or indeed from those of the university itself. The court considers that in assessing whether a body is a college of a university, the following 5 questions are likely to be highly relevant. 1, whether they have a common understanding that the body is a college of the university. 2, whether the body can enrol or matriculate students as students of the university. 3, whether those students are generally treated as students of the university during their course of study. 4, whether the body provides courses of study which are approved by the university. And 5, whether the body can present its students as candidates for examination for a degree from the university. The court finds that the First-Tier Tribunal carried out a careful and comprehensive evaluation of the evidence. It found, among other things, that SEL, as the United Kingdom arm of SAEI, had been an associate college of Middlesex University since May 2009, and that the parties had proceeded on that basis. That the links between SAEI and the university were well established and likely to endure, that most of SEL's courses were supervised by the university and their quality was regulated by the university, that SEL's purposes were similar to those of the university, that SEL students became students of the university and received degrees from the university, and that the activities of SEL were substantially integrated into those of the university. The First-Tier Tribunal was entitled to find that in May 2009, SEL became, and thereafter remained, a college of Middlesex University within the meaning of Note 1b. The Upper Tribunal and the Court of Appeal had no proper basis for interfering with those findings. Accordingly, it is the unanimous decision of this court that SEL's appeal must be allowed.
Thank you. The court is now adjourned.